some of the submissions made by the state, it's really necessary to go back to the beginning. Now, the disadvantage, as your worship knows, of any applicant in a bail application, is he doesn't have access to the docket. And the law essentially says, show me yours, but we're not going to show you ours. So what we have in applicant number 4 is an applicant who has been proactive. Now, how do you challenge what the state is going to say in your founding affidavit without trying to get some insight into what the state is going to say? For the most part, an accused can't, because he doesn't have access to the docket. Except in this case, and it was on the news. There was the application in Swaziland for the extradition of 2 suspects to be joined to this case. Now, these accused are arrested, and it's all over the news. There is this application. In fact, I think even the Commissioner of Police said he's disappointed with the counterparts in Swaziland for releasing everything to the media. So, in order to be proactive, in order to take the fight to the state and say, right, we're going to address each and every of your allegations because we've got nothing to do with it. The instruction was for my attorney to drive to Swaziland to get hold of the extradition papers, because any party requiring the extradition of any individual has to set out the basis of the case against that person. And that then gave this applicant insight into the case that he needs to meet. Now, I would surmise that that is why the state wasn't very happy with it, why they didn't want it included in this case, because it also serves to restrict what the investigating officer is going to say. He can't say anything he wants without any of us being able to check and say, well, yes it is, no it isn't, until we're allowed access to the docket when the matter is trial ready. And then following that objection, Your Worship ruled for various reasons initially that it wasn't admissible, and those aspects in the applicant's affidavit had to then be redacted. Now, the relevance of what I'm saying to Your Worship comes down to the 800,000 rand. And the state saying with some glee, well, how would they have known about the 800,000 rand, etc.? Can I take Your Worship to the applicant number 4's founding affidavit, paragraph 92. Because let's not forget, Your Worship, the state is trying to say we kept quiet about the 800,000 rand. We didn't put up bank statements for the 800,000 rand. That was their submission. But let's look paragraph 92. And let us not forget that this was deposed to on the 19th of March. Paragraph 92 reads, I shall now deal with the allegation, certainly as stated in the media, that I received 800,000 rand the day that the deceased was killed and that I transferred 133,000 rand to Linda Kuchler in Demonde. So it was already set out there. It was no secret, like the state would want Your Worship to believe. They're hiding, they didn't put up their bank records, hiding the fact that period because it's the 800,000 rand. No, it was already set out in the applicant's founding affidavit. Then paragraph 93. The 803,000 rand was paid to me from a reputable company whom I've done business with before. In fact, our business relationship goes back as early as 3 years back. Now, that really deals with the state's submission that applicant number 4 is trying to hide something in respect of not putting up banking records. And that is why we say it's common cause. It was out there in the media. It is, of course, my learned friend's words. We live in a digital age. Now, that really...
Where is the statement for December up to March, December 2022?
Well, Your Worship, if it's not there, it's not there.
But the question is where?
Well, I would suppose with the banks it can be accessed by the police. But the importance of it is not the fact that there are no bank records. It related to the 800,000 rand. That was the silver bullet that the state was looking for. That is, as I understand the state's submissions, as to we were attempting to hide this. But no, there was a full disclosure from the onset.
We cannot say it's a full disclosure when there is a bank statement or part of the bank statement that is missing, and we cannot answer to the question, where is it?
I hear Your Worship. I'm referring to full disclosure in respect of the 800,000 rand, which forms the bedrock of linking accused number 4. And I stand by that submission respectfully, Your Worship. Now, on that part...
Where is the statement from December up to March? This is accused number 4, the guy who received the 800,000 rands from the Gcaba brothers, from one of the Gcaba brothers. And he doesn't have parts of his statement. Which parts? December up to March. As you know, AKA and Tibz were unfortunately gunned down in February. So the court just wants to see the statement from December up to March. And I'm not sure why they need the statement voluntarily produced by accused number 4. I guess maybe because this is a bail hearing. So it's on the accused to prove that they deserve to get the bail. I think that's what's going on. But we obviously know the court can just grant section 205 and then that can be retrieved from the bank. But notice how the advocate says, after the judge says, where's the statement from December up to March? And he says, if it's not there, it's not there. If this was my lawyer, I would be so mad. And he remains arrogant as he continues to speak with this judge. With regards to those statements, why are these statements such a big deal? Why is it so difficult to produce the statements if it's such an honest transaction? But continue listening. You will hear what other things he has to say about the 800,000 rands, because I say, wow.
On that part, often it is not what is said, but it is what is not said. Your Worship, and even though Your Worship probed my learned friend, no mention made of Mfundo Gcaba, the man who paid the money to applicant number 4. What did the state say in relation to that? Let's have a look. The affidavit of the investigating officer, page 25, I think it is, Your Worship. Is Your Worship with me?
Yes, I'm with you. Thank you.
The money was transferred from a bank account of the company Bright Circle Pty Ltd. According to the company records, Mr. Sidney Mfundo Gcaba is the sole director of this company. When the money was transferred, a reference was used as consult. This, we are of the view, was done to disguise the nature of the funds, as same is viewed to be payment for the shooting. Yet the person who paid for the shooting, once again, isn't an accused here. Your Worship has not been addressed by the state on that aspect. And I would submit he's not here because the state is scared. For reasons only known to them, they are scared to make this arrest. Now, the reason why they're scared is because there's no evidence, because it is exactly that. One reputable businessman paying another reputable businessman for work done. The problem that the state has, and that they want to make our problem, is as long as our answers do not suit them, as long as our answers do not fit in with their preconceived narrative, they will say, we're not happy with that answer. But quite frankly, it's not for them to be happy with. It is Your Worship. Given the information that applicant number 4 has been able to search for, has been able to obtain, he's addressed everything. Now, I stand by my learned colleagues and their submissions, and I agree particularly, my learned friend in his address gave what I would say a fair amount of evidence. Now, yesterday, when I addressed Your Worship kept me on my toes. You say this, where did you deal with it? What paragraph, what page? And I'm sure that when Your Worship considers all of the evidence and our addresses, Your Worship will then look at what my learned friend said today and say, fine, what paragraph do I find that in the state's affidavit? And I'm going to submit to Your Worship that much of what was said today, Your Worship will not find, because it's not in the affidavit. And I'd like then to refer Your Worship to this decision. It is Maboho, it's spelled M-A-B-O-H-O, so it's Maboho T, and 117, as in the number, 117, related cases versus the Minister of Home Affairs. The citation is 2011 ZA-LM PHC4, and it deals with the question of argument. Your Worship will find it at page 7 of the judgment. Argument is not evidence, and it is not given under oath. It is merely a persuasive comment made by the parties or legal representatives with regard to questions of fact or law. Argument does not constitute evidence and cannot replace evidence. That, Your Worship, deals with everything my learned friend has said to Your Worship today that is not in their affidavit, and that's a lot. Then, Your Worship, just various aspects that were raised. Now, my learned friend has made mention of the reference relating to the payment following applicant number 4 receiving the 800,000 rand. Words like shares, wedding, and so forth. Well, that is what is there. There's nothing illegal in that. There's nothing concealing in that. You can put any reference you want. Could be your share for the work. Now, Your Worship will also recall that from the onset, in relation to the averment that applicant number 4 was at the airport, that he paid for parking, that he was in the BMW, from the onset, applicant number 4 said, and it's in the affidavit, the airport is a national key point. It has CCTV coverage. I challenge the state to produce CCTV footage of me in the vehicle. Today the state answered that, and the answer was, we don't have any. Can't see who it is. Alternatively, and that's only from the toll road, the other part of the answer was, well, the airport doesn't keep it for that length of time. Now, the beauty of the applicant's affidavit, deposed to when it was, is that it's a contemporaneous note and recordal of various things. When he deposed to that affidavit, there is nothing to suggest that he has some inside knowledge of how long an airport keeps their CCTV footage. So when he challenges the state and says, I challenge you, show me the TV footage, I submit that some weight has to be attached to such a challenge. Now, in respect of the toll plaza coming from the airport, my learned friend has forgotten. If you drive from Verulam through and you join the N2, you go through that same toll plaza. It is not just restricted to the airport. And from Verulam, well, you can go in various directions all over, really. So no, it doesn't. It's not a one-way road only from the airport to the toll plaza. That's wrong. Similarly, Your Worship, the statements that were found in the cubbyhole pertaining to the BMW. Now, I've submitted yesterday, I submit again. It's not interference. Applicant number 1 was never an arrested person at that stage. He was never a suspect for anything at that stage. But it is consistent with applicant number 4 saying and maintaining, I've done nothing wrong. I'm proactive. I'd like to answer the allegations. That's why my instructing attorney was sent to obtain the extradition papers. Let us see what they say so I can address it. I'm not going to shy away from what he said. I'm going to deal with it. And that's what he did. That's what any law-abiding citizen should do.
Getting statements from witnesses for the state.
Well, Your Worship, there's no... Yes.
Huh?
And they're not witnesses in this matter.
No, but they are witnesses in a case.
Yes, Your Worship, but at that stage, this applicant was not a suspect. He didn't know he was a suspect.
What business did he have with getting witness statement?
Once again, Your Worship, you want to clear up what has occurred. I notice Your Worship shaking your head.
Yeah, no, I'm really shaking my head because what you're saying now, really, I don't agree with respect.
And that's fine. I take Your Worship's point.
Yes.
So, a Magistrate Vincent Hlatswayo obviously wears his feelings on his sleeves, and the attorney immediately catches that on, that he was shaking his head, and he says, why are you shaking your head? I notice you're shaking your head. This was after the magistrate asked, wait a minute. So accused number 4 is driving around with witness statements in his car, but is not arrested. Why is he driving around with witness statements? And the attorney says it's because he was being proactive. And this is when the magistrate starts shaking his head like, I cannot believe this. And the other thing that occurred is that the attorney says the state is afraid of Sidney Gcaba because why is he not arrested? The state knows full well that the 800,000 rands was transferred into accused number 4's business account by Sidney Gcaba, who are both two very, very innocent business people who have had a business relationship for over 3 years. But if they're going to arrest one, why can't they arrest the other? I think that's a valid and fair question. And I think that's what the nation wants to know as well. Why Sidney Gcaba had to write his brother had to write, that's another story for another day, while his brother had to write a press release for his brother, who is being implicated to be the one who supplied the money. So to be the Ngondo for the AKA Tibz murder, but he's not arrested. This plot already sounds very familiar with the Senzo Meyiwa trial, but it's too soon to tell what's going on, and it sounds to me like the state is still investigating. That again sounds familiar because we see Valo is still producing paperwork 10 years later. Anyway, I digress. So now this is what's happening. I mean, I think the judge is not shy to express how he feels immediately. But then some will argue and say, well, there's been too much noise about Rata expressing himself. Rata doesn't express himself as a judge. He becomes a witness and a prosecutor. That is where the confusion lies. But let's continue listening on. Let me know in the comment section, do you think accused number 4 will be granted bail? Before the judge shook his head, I want to say yes, his attorney was bringing up valid points because everything is just circumstantial as opposed to factual, especially when the state said they do not have video evidence, but they do have the BMW following AKA from the airport. Okay, they do have accused number 4 swiping his virtual card at the airport parking. And then they have him at a toll, but they don't have a picture of him. They have the picture of the BMW, but they don't have a video of him. They cannot see who the driver is. And it was in that moment that I said, well, proof is proof. Proof is proof. But let's listen on.
Now, to touch on the cell phone, as my learned friend has said, we live in a digital age. What they don't take into account is you can have numerous virtual cards, same card, duplicate, identical cards, linked to various cell phones. You can have duplicate SIM cards. SIM cards can be swapped. So it's not clear-cut as the state would like to suggest. But in any event, that's not evidence before your worship, because it's not in the affidavit. Demonstrate that the release of these applicants on bail would cause a public outcry. No evidence led. So, the last point, your worship, if I may, is the missing cell phone. My learned friend made mention of the fact that a case was opened at IPID and that the phone wasn't listed. What he has forgotten to mention to your worship was that it's the applicant's wife who opened the case, not him. But over and above that, how often does it occur that someone, for example, is the victim of a housebreaking and they give a statement to the police or to the insurer to say, these were the things that were taken. And sometime down the line they remember, oh yes, it's this, and oh yes, it's that. So that would be my response in relation to those two aspects. I note my learned friend in argument did not address the chances of applicant number 4 absconding, and I take that as a concession. There's no evidence to suggest he would abscond if your worship should release him on bail. There is no evidence that he would interfere with witnesses, tamper with evidence, and there's no evidence of a public outcry. So in conclusion, your worship, applicant number 4 has gone the extra mile to address in his founding affidavit what the state will say the case against him is, by obtaining the papers in the extradition, as well as just addressing what he saw on the media. So, your worship, my closing submission would be he has discharged the onus. It is in the interest of justice that he be released on bail with appropriate conditions and in an appropriate sum, as your worship should see fit.
I would have loved to give judgment before the 15th, but unfortunately, I'm away the whole of next week. I'm out of office and cannot even venture coming to this side. So I propose that we stick to the original date, which is the 15th, the date that we all agreed upon. Do we still confirm the date as the 15th?
If I can only confirm if it's the 15th of May.
15th of May.
Thank you, Bishop.
Thank you, Mr. Yes, it's the 15th of May.
That's a
week after next. Applicant may rise. Gentlemen, the matter against you is then postponed for judgment until the 15th of May. On that day, I'm sure I'll be able to pronounce myself on the issue of bail. Do we have the court book here?
And there you have it, Mzansi. Magistrate Hlatshwayo confirming the 15th of May is finally the day that the accused are going to find out if they will be granted a bail in the AKA and Tibz murder. Quite interesting exchange between the attorney and this magistrate. But your thoughts in the comment section down below. Does accused number 5 deserve bail? Did his attorney present a good case for him? The attorney did mention that the cell phone, there's a missing cell phone. For me, that's a little bit sus. Who really loses their cell phone and just doesn't even report it? It hasn't been handed in, even though the state has requested it. What are you hiding on that phone? But again, Section 205. So another thing is that they say, well, it wasn't reported as stolen because accused number 4's wife is the one who opened up the case. But remember, accused number 5, and I hope the magistrate remembers this, the accused number 5 has 2 wives, okay? He has the one who's a doctor, and I believe the other one is a student studying to be an attorney. Let me know in the comment section if I got that right. And because of that, the attorney does not mention which wife it is. And I think, it's important to put the specifications in detail so that the state knows which wife to call in as a witness. Okay, so that's it from us today. Looking forward to the bail hearing judgment. Remember to leave a comment. Let us know your thoughts thus far. And as well, remember to like the video. I promise when you hit the like button, you're going to see some colors jumping up and down. So like that button, hit the like button, and catch you on our next upload.